Hi everyone, I'm Wenshen. Today, our group will be talking about sexual offences against adults under the Malaysian Penal Code. According to the Department of Statistics Malaysia, there were 1,899 reported rape cases in 2025, an increase of 12.1% from the previous year. Cases of rape without force went up by 29.3%, although rape involving force actually dropped by 15.3%. Overall, this statistic clearly showed that sexual offences remains a serious concern in Malaysia. But here's the thing. Many victims never report sexual offences. Why? Because of fear, shame, stigma, or simply because they don't trust the justice system to help them. As a result, the actual number of cases is likely much higher than the official statistics show. Now, why are we talking this today? Because many university students have limited awareness of what the law actually says about sexual offences under the Penal Code. We aim to explain the key legal provisions that every student should be aware of. When we say adults, we mean persons who are 18 years old and above. Offences involving children are dealt with separately under the Sexual Offences Against Children Act 2017, and that's outside what we are covering today. And when we talk about sexual offence, we are focusing on specific sections in Chapter 16 of the Penal Code. We will focus on Section 375, the definition of rape, the Section 375A, a husband causing hurt to force intercourse, Section 375B, gang rape, 7376, the punishment for rape, and the Section 377 series of offences relating to carnal intercourse against the order of nature. You might ask, why the law contains these provisions? The answer is that the law recognizes every person's right to bodily autonomy, personal dignity, and sexual integrity. Sexual offences are not just acts of physical violence, they are serious violations of a person's freedoms and consent. The Penal Code aims to punish offenders, protect vulnerable persons, and uphold public morality. These provisions are all based on one key principle: consent must be real, voluntary, and legally valid. Let us briefly look at Section 375, which defines rape through 7 different circumstances, ranging from acts done against a woman's will to situations where consent is obtained through fear, misconception, or abuse of authority. We will be going through each of these in detail throughout this presentation. As for the flow of today's presentation, Shirley will discuss the actus reus of rape, focusing on circumstances A and B. Zheng Jie will cover circumstances C to G and the marital exception under Section 375. Zhao Jing will examine the punishment under Section 376 and the controversial case of Noor Afizal bin Azizan. Edison will discuss offences under 377, including the leading case of Bunya Ak Jalong against public prosecutor. Xing Yan will conclude by comparing Malaysian laws with reforms in India and Malaysia, and give practical guidance for victims and witnesses on what to do if a sexual offence occurs. Before I hand over to Shirley, I would like to leave 3 important points to keep in mind throughout this presentation. First, consent in Malaysian law is contextual. Silence for the absence of physical residence does not necessarily amount to consent. The courts look at all the surrounding circumstances. Second, rape under Section 375 is still gender-specific. Under the current law, only a man can legally commit rape, and only a woman can be recognized as the victim. Third, many of the criticisms made about Malaysian law in this area are not new. Countries such as India and Singapore have already introduced reforms to address similar problems. And later in this presentation, we will consider whether similar reforms should be adopted in Malaysia. Let us now turn to Section 375, and Shirley will now explain the actus reus of rape.
My name is Ling Shirley, and I'll be explaining on the sexual offense of rape under the Penal Code. So, to understand the sexual offense of rape under the Penal Code, we must first identify the actus reus, which is the physical element, and the mens rea, which is the mental element of the offense. Section 375 provides that rape is a man who, excepted in the case hereinafter accepted, has committed sexual intercourse with a woman falling under the circumstances following the descriptions in subsection A to G. While the mental element is not specifically provided in the provision, it can be seen embedded in the specific circumstances, the limbs of the acts. So, following the provision, three main elements need to be satisfied to find rape. First, the perpetrator must be a man. Second, the victim must be a woman. And third, the act must fall under one of the circumstances in subsection A to G. Now, before diving into the subsections, it is important to understand what is meant by sexual intercourse in the Penal Code. This is provided under the explanation of section 375, where penetration alone is sufficient to constitute to a sexual intercourse for the offense of rape. Now, one might ask, penetration by what? Does the depth matters? Is ejaculation necessary? So the courts have provided the answers for these gaps under common law. For example, in the case of Nasrul Anwar bin Abdul Samad, penetration must be done by the male sexual organ. In Sidat bin Ludwan and Public Prosecutor, the courts held that mere entry of the male sexual organ into the labia is sufficient. And in Ahmad Najib bin Anis, ejaculation is not an element of the offense and is therefore irrelevant. Now, turning to subsection A and B of section 375 of the Penal Code, subsection A is described as against her will and subsection B as without her consent. While both the subsections may sound similar to each other, they actually carry different meaning. To fully understand the distinction between the two, we will look at the Indian position on this era. So, this distinction is made clear in the Indian court case of State of UP and Choti Lal, where the courts explained that the expression against her will would ordinarily mean that the intercourse was done by a man with a woman despite her resistance and opposition, while without her consent would comprehend an act of reason accompanied by deliberation. These principles can be found applied in Malaysian cases. For example, the recent High Court case of Pendakwa Raya lawan Sheikh Shah Iqmal, where the victim struggled and tried to break free from the accused, fulfilling subsection A, and was crying, feeling scared, fulfilling subsection B. Here, the meaning of consent is important. So, under the Penal Code, it does not provide what amounts to consent, but it defines what does not amount to a valid consent. Under section 90 of the Penal Code, consent is invalid when it is given under fear or misconception of fact which the person doing the act has reasonable belief in, or where the person giving the consent is in a state of unsoundness of mind or in a state that is so intoxicated that the person is unable to understand the nature and the consequences of the consent, or when the person is under 12 years old. So what happens when consent is withdrawn halfway through the act? Similar to English position, penetration is treated as a continuous act in Malaysia. Therefore, once consent is withdrawn, continuation of the act may amount to rape. Now, I will pass it on to my team members to further explain on the circumstances of section 375.
I'm Zheng Jie, and now I'll be covering the circumstances C to G of section 375, the marital exception, section 375A and 375B, and the defense of mistake of fact under section 79. Circumstance C has two distinct limbs, fear of death or hurt, and misconception of fact. On the fear limb, hurt under section 319 includes bodily pain, disease, or infirmity. Infirmity is read broadly in Joshua Jatmakal v. Brahmanan. Hysteria was held to constitute infirmity without physical contact. In Maharashtra v. Prakash, consent extracted through threats by a police officer is no consent at all. Ali bin Ayun applied this locally where the accused threatened the victim with a chopper. On the misconception limb, in Tai Hui Hiong, the victim was told a ghost would haunt her unless she complied. The court held misconception need not involve physical threat. It is sufficient that it destroyed her freedom to choose. Section 90 subsection A covers similar grounds, making circumstances C somewhat duplicative, but as the specific provision, section 375C governs. Circumstance D is narrow, arising in identity deception cases. It applies where the victim consented believing the accused was her husband or a man she would otherwise consent to, and the accused knew otherwise. This is broader than the English position under Section 76 of the Sexual Offences Act 2003, which limits impersonation to someone personally known to the victim. Circumstance E covers victims unable to understand the nature and consequences of their consent. Mirroring Section 90 subsection B, it captures severe intoxication and unsoundness of mind. Ordinary intoxication will not suffice. Circumstance F, strengthened by amendment, covers consent obtained through abuse of authority or trust, reaching guardians, teachers, doctors, religious figures, and employers. Structural power cannot mask absent consent. The imbalance itself negates genuine freedom of choice. Circumstance G makes intercourse with a girl under 16 rape regardless of consent. In Jamaluddin Hashim and Yet Kok Soon, convictions were secured without proving absent consent. However, Rosie bin Ramli suggested the accused's knowledge of age was relevant, leaving the position unsettled. The better view is that Circumstance G should operate as strict liability, as the legislative intent is to protect children absolutely regardless of the accused's belief as to age. On the marital exception, Section 375 provides that a husband cannot be convicted of raping his wife under a valid subsisting marriage. This reflects the outdated common law fiction of implied marital consent, which was abolished in England in AVIA but deliberately retained in Malaysia. The exception does not apply where there is judicial separation, where a decree nisi has not yet become absolute, or where a court injunction restrains the husband. Outside these situations, non-consensual marital intercourse is simply not rape in Malaysia. Balasingham and Sabaruddin argues that the exception and Section 375A together legitimize rape within marriage and should be deleted entirely, leaving wives with no remedy unless physical violence accompanies the act. Section 375A provides limited relief where a husband causes hurt or fear of hurt to compel intercourse. He faces up to 5 years imprisonment, but this is not rape. The punishment is far lower and captures only physically coercive conduct. Non-violent marital rape remains entirely outside the law. Section 375B addresses gang rape, where a woman is raped by persons acting in furtherance of a common intention. Every member is deemed to have committed gang rape, even non-penetrating members. Punishment is 10 to 30 years, consistent with Section 34 on common intention. Finally, Section 79 provides a defense where the accused generally believes himself justified through a mistake of fact. Section 52 clarifies that good faith requires due care and attention. Recklessness will not suffice. In Teo Eng Chan, the defense was rejected as the accused had taken no reasonable steps to ascertain the victim's age. Given the high Section 52 threshold, this defense is effectively theoretical rather than practical in rape cases. I now hand over to Qiao Jing, who will take us through the punishments under Section 376.
I'm Qiao Jing, and now I will be explaining Section 376 of the Malaysian Penal Code, which deals with the punishment for rape. Section 376 is divided into 4 main limbs. Subsection 1 provides the basic punishment for rape. Subsection 2 covers aggravated rape. Subsection 3 deals with the incestuous rape. And finally, Subsection 4 concerns rape causing death, which is the most serious category under this provision. Starting with Section 376, Subsection 1, this subsection sets out the basic punishment for rape. A person convicted under this provision may be imprisoned for up to 20 years and may also be punished with whipping. The important point here is that whipping is discretionary because the section uses the words liable to whipping. This means that the court may impose whipping, but it is not mandatory in every case. The subsection reflects the seriousness of rape as a violent offense that violates bodily autonomy and personal dignity. Next is Section 376, Subsection 2, which deals with aggravated rape. Here, the punishment becomes much more severe. An offender may face imprisonment between 10 and 30 years together with whipping. This subsection contains 11 aggravating circumstances that justify harsher punishment. These circumstances shows that the broad range of situations in which rape becomes even more serious. For example, aggravated rape includes cases involving violence or threats of violence, abuse of authority or position, rape against vulnerable victims, and conduct causing serious psychological trauma. It also covers situations involving the transmission of disease or where the victim is driven to suicide as a result of the offense. The law therefore recognizes that some rape offenses involve additional cruelty, abuse of trust, or particularly harmful consequences, and these factors justify heavier punishment. Moving on to Section 376, Subsection 3. This subsection concerns incestuous rape. It applies where the accused is prohibited from marrying the victim under law, religion, custom, or usage. In other words, the subsection targets rape committed within prohibited family relationships. The punishment under this provision is imprisonment between 8 and 30 years, together with a minimum of 10 strokes of whipping. The mandatory minimum whipping reflects society's strong condemnation of incestuous sexual offences, especially because they involve betrayal of family trust and often exploit vulnerable victims within the household. Finally, Section 376, Subsection 4, addresses rape causing death. This subsection applies where death is caused during the commission or attempted commission of rape. Because of the extreme gravity of the offence, the punishment is the most severe under Section 376. The offender may face either the death penalty or imprisonment between 15 and 30 years, together with a minimum of 10 strokes of whipping. This subsection demonstrates that the law treats rape resulting in death as one of the gravest offences against both personal security and human life. Before I conclude, I would also like to highlight an important sentencing issue through the case of Noor Afrizal bin Azizan. In that case, the accused was released on a bond of good behaviour despite being convicted of rape under the former Section 6 Subsection A of the Criminal Procedure Code. The decision received significant public criticism because many believe rape was too serious an offence for such lenient treatment. As a result, the law was amended. Under Section 172D, Subsection 4 of the Criminal Procedure Code, a serious offence now includes offences carrying a maximum imprisonment for at least 10 years. Since rape under Section 376 clearly falls within that category, offenders convicted of rape can no longer be released merely on a bond of good behaviour. This amendment strengthens public confidence in sentencing for sexual offences. In conclusion, Section 376 establishes a structured framework of punishment based on the seriousness of the rape offence, from basic rape to aggravated rape, incestuous rape, and rape causing death. The provision reflects the law's intention to protect victims and impose increasingly severe punishment where aggravating circumstances exist. Edison will now continue with the Section 377 series, which deals with offences relating to carnal intercourse.
Hi, my name is Edison. I will discuss Section 377 of the Penal Code, a section that is mainly about intercourses that are against natural order. Let's start with Section 377A. This section defines carnal intercourse against the order of nature, which legally means the introduction of the penis into the anus or mouth. Section 377B sets the punishment up to 20 years in prison and mandatory whipping. You must understand the reality of this law. 377A is a seizable offense. This means a police officer can arrest you on the spot without a warrant. Furthermore, under Section 2, Subsection 1 of the Criminal Procedure Code, this is classified as a warrant case, meaning if convicted, the prison sentence cannot be less than 6 months. If you are ever accused under these sections, you need to know how the court handle it. In the Dato Seri Anwar Ibrahim case, the court ruled that an accuser cannot just guess the date. The exact time frame is a material ingredient that must be strictly proved. The court also warned that it is highly unsafe to convict someone based solely on uncorroborated oral testimony. Now, what if these acts are done by force or without consent? That falls under Section 377C. Because force is involved, the punishment is a strict minimum of 5 years up to 20 years plus whipping. Just like 377A, this is a seizable warrant case under the CPC where police can arrest without a warrant. And for absolute clarity on what this covers, in the case of Chang Wan-chuan, the court specifically ruled that forced oral intercourse falls directly under this severe 377C charge. But for a long time, there was a terrifying gap in how the law protected the victims of assault. Let me tell you about the case of Bunia Ak Jalon. A 15-year-old girl was assaulted and made pregnant by the accused. Shockingly, he escaped a standard rape conviction. Why? Because the old law strictly required penile penetration and the accused proved he used his semen-covered fingers. But today, Section 377CA solved that horrific loophole. If someone sexually assaults you using any object or any part of the body, like fingers, it is a severe crime carrying 5 to 30 years in prison plus whipping. You are fully protected. Next is Section 377D, gross indecency. This covers indecent acts in public or private. What counts as gross indecency? The courts define it as behavior that would be considered grossly indecent by any right-thinking member of the public. But specific details matter in court. In the Sukma Dharmawan case, the prosecution tried to use this broad law to secure a conviction. However, because the prosecution explicitly wrote the word penetration on the charge sheet, they were legally bound to prove it. The facts drafted must match the physical evidence. Finally, as students, you should know that many legal experts are pushing for major reforms. Researchers in the Journal of Muafakat 2023 argue that punishing consensual acts between adults violates our constitutional rights to personal liberty and equality under Articles 5 and 8. Furthermore, a 2022 paper in the International Journal of Law argues that mandatory whipping for consensual acts is a cruel legacy of British rule that violates human rights and must be abolished. Understanding these laws isn't just for law students, it is for your own safety. Always respect consent, know what the law says about your body, and never be afraid to speak up and report an assault. Stay safe and take care of each other. Now, Xingyan will close with comparative reforms and practical advice for students.
I'm Xingyan, and I'll be discussing the comparative reforms in India and Singapore while proposing reforms to Malaysian law. And most importantly, practical advice that university students should know regarding sexual offence against adults. To begin with, India introduced major reforms following the 2012 Nibaya case, which sparked nationwide concern regarding the protection of victims of sexual offences. The case involved a 23-year-old female student who was brutally assaulted and gang raped by 6 men on a moving bus. This causes widespread public outrage and became a turning point in India's sexual offence law. Following the recommendations of the Justice Verma Committee, the Criminal Law Amendment Act 2013 significantly expanded Section 375 of the Indian Penal Code. Previously, rape was largely limited to penile vagina penetration. However, the amended version now includes penetration of the vagina, mouth, urethra or anus by the penis, any object or any part of the body. In addition, the reform also introduced stronger punishments such as life imprisonment and death penalty, particularly when the victim dies or is left in a persistent vegetative state. In addition, India also raised the statutory age of consent to 18 years old, reflecting a broader and more victim-centered understanding of sexual violence. Most importantly, India expressly criminalizes digital, meaning finger penetration, and also object penetration as rape. This addresses a gap highlighted in the case of Bunya Akjalong, where finger penetration fell outside the traditional definition of rape under Section 375 of the Malaysian Penal Code, with Section 377CA only mentioning object penetration. Overall, these reforms mark a major shift toward a more victim-centered approach in India. However, challenges such as delays, lack of awareness, and inconsistent victim support still affect its effectiveness. Moving on to Singapore. The country also introduced significant reforms through amendments made in 2007 and 2019. Under Section 375 of the Singapore Penal Code, rape includes penile vagina penetration without consent, as well as penile oral and anal penetration committed against both male and female victims, reflecting a more gender-inclusive approach towards sexual offences. In comparison, Section 375 of the Malaysian Penal Code still defines rape primarily as penile vagina penetration by a man against a woman. Overall, Singapore adopts a broader and more inclusive approach towards sexual offences, providing stronger protection for victims and placing greater emphasis on accountability. Having considered reforms in India and Singapore, it is also important to evaluate possible reforms for Malaysian law. Firstly, Section 377CA could be amended to expressly include any object or any part of the body except the penis, similar to the approach adopted in India and Singapore. Such an amendment would close the current gap relating to digital penetration. Secondly, Malaysia could consider reviewing and strengthening the statutory age of consent in order to provide greater protection for minors, in line with developments in jurisdictions such as India. Thirdly, Malaysia could consider introducing stronger punishment for sexual offences involving severe injury, death, or particularly vulnerable victims, similar to the enhanced penalties adopted in India.
Lastly, Malaysia could consider reviewing the gender-restricted definition of rape by adopting a broader and more inclusive approach similar to Singapore. This is important because at present, Section 375 of the Malaysian Penal Code still limits rape primarily to penile vaginal penetration committed by a male offender, meaning female offenders do not fall within the principal rape provision regardless of the seriousness of their conduct. As a result, prosecution may need to rely on separate offences that do not carry the same doctrinal meaning or level of condemnation associated with rape. Apart from understanding the law and possible reforms, university students should also know the practical steps to take if a sexual offence occurs. Firstly, the priority is safety. Victims should immediately move to a safe place and seek medical treatment as soon as possible, preferably within 72 hours at a one-stop crisis centre in a government hospital. Early medical attention is important not only for treatment, but also for preserving forensic evidence. Victims should also try to preserve any available evidence by avoiding showering or changing clothes if possible, keeping screenshots and messages, and take note of possible CCTV locations or witnesses. Once this is done, lodge a police report and the investigating officer will then begin the formal investigation. Beyond legal steps, students should also know that support services are available. This includes Talian Kasih 15999, the Women's Aid Organisation hotline, and the Police Emergency Line 999, as well as University Counselling and Wellness Centre. Seeking help early can make a significant difference as it provides emotional, medical, and legal support. In addition to supporting victims, students can also help prevent harmful situations through bystander intervention. One common approach is the 5 Ds. First, distract, which means interrupting the situation indirectly, for example through a small talk or creating a distraction. Secondly, delegate, which involves asking trusted third parties such as security officers or lecturers for help. Thirdly, document, which refers to safely recording the incident while recognizing that sharing the evidence is the victim's decision. Fourthly, delay, which means checking on the victim afterwards to offer support. And lastly, direct, which refers to safely stepping in when inappropriate behavior is happening. In conclusion, Malaysia's sexual offence law provides important protection against several sexual violence, but certain gaps still remain. Comparative developments in India and Singapore demonstrate broader approaches toward consent and victim protection that Malaysia may learn from them. Ultimately, university students should understand the importance of consent, know where to seek help, and support one another in maintaining a safe and respectful university environment.